Hello, everyone, and welcome to the webinar, COVID-19 Conversations, Returning to the Workplace, Legal Considerations for Employers. My name is Gabby Lemon, and I'm the event specialist here at Workplace Safety North. We appreciate your attendance here today and want to let you know COVID-19 Conversations is an ongoing webinar series that features a monthly webinar from May to August on issues related to the current global pandemic. Before we get started, we want to mention a few housekeeping items. Your microphones have been muted, and we ask that you use the Q&A at the bottom of your screen for speaker questions. If you have any technical issues using the Zoom application, do let us know in the chat box, and we'll do our best to assist you. So to clarify, please put any commentary or technical questions in the chat box and speaker questions in the Q&A section. Resource information and a recording of today's webinar will be sent to you within 1 business day. Now I'd like to pass things over to co-host Angele Poitras, Community Engagement Specialist and Certified Psychological Health and Safety Advisor at Workplace Safety North. Welcome, Angele.
Thanks so much, Gabby, and welcome to each and every one of you. Thank you for investing an hour of your time, and our guest today, Brad Smith, and I will try to make it a high return on investment for you. So when we did our registrations, you may recall that we asked you some questions. We provided you an opportunity to ask questions. And so what we've done is we've looked at each and every question and we've put them into 3 major themes. And so it is our hope that we will capture and answer many of your questions. If not, Brad Smith will provide an email address and in your information that goes out to you, and he will accept some emails from you if we don't get to all of your questions. So every session that we have with you, we like to know a little bit about you. So today, Gabby is going to run a poll, and we're going to ask, are you an employee or an employer? So Gabby will put the poll on the screen, and while you're actually answering the poll, I'd like to tell you a little bit about who Workplace Safety North is. We're one of the health and safety system partners in Ontario. We're located and headquartered in Northern Ontario. We have staff right across the north. Our traditional roots were in forestry, mining, and pulp and paper, but we've expanded our expertise to serve all Northern Ontario businesses. And when we say businesses, we also include not-for-profit organizations. We have a legacy that is over 100 years old, and this year we are celebrating our 10th anniversary. And our COVID Conversations is a new venture for us during that time. So if you have questions around health and safety, please reach out, and one of our talented experts would be more than happy to provide you with some answers. So Gabby, do we have our poll results yet? Oh, we do, and look at that. It's pretty well even split between employers and employees. So what we're going to try to do is put our questions around knowing that half of you are employers and half of you are employees. So my guest today is Brad Smith, and Brad joins us from Thunder Bay, where he's a partner at Weilers Law. He practices labor relations and employment law, and he's also Weilers' Gender Diversity Officer. Brad is very proud of his status as a member of the Cree Nation, and I've had the opportunity to see Brad in action for many years. He is a very trusted expert for the health and safety community of the North. So welcome, Brad. There's been a lot of news this week as we enter into phase 3. And this week, our viewers had a lot of additional questions. So Brad, before we head into the 3 themes, if we could ask you a question about face masks. We've had notification that most communities are going to be having a bylaw around face masks, and that is including workplaces. So the questions around masks are as follows, Brad. Can a workplace enforce a mask wearing policy? If an organization, business, makes masks mandatory, does the employer have to pay for it, or is that an employee cost? So Brad, the floor is yours, sir.
So good morning or good afternoon, everybody. Certainly interesting times, and I thank you for giving me the opportunity to speak to you this afternoon. Hopefully it's worth your time, and you're giving up not only an hour of your time, you're giving up the most important hour, the lunch hour. So in terms of dealing with masks, obviously this is a situation where first, we've got to see what is going to happen with the law, whether or not that's going to be something imposed by municipalities, by the Ministry of Labor, by Ministry of Health, regulations, et cetera. So we're going to have to see whether or not it's going to be imposed on, not on only employees, but imposed on employers. But if it's not imposed on everybody or certain specific sectors, because I think we can probably suspect that there will be some sectors that they'll target where masks are mandatory, and other sectors it will maybe discretionary. So if it's within the discretion of the employer is going to have to create a policy where they're going to require a mask in a given set of circumstances. But that creation of that policy and the contents of that policy is going to be quite complicated, because there's a lot of questions that an employer is going to have to address. And to some extent, it raises the same questions we get in any situation when we're dealing with personal protective equipment, in terms of what's the rationale behind the personal protective equipment? Is it appropriate in that sector, that industrial sector, or is it appropriate in that particular workplace, or is it appropriate to all of the employees in a given workplace? So there's a lot of questions that have to be asked, because it's not necessarily going to be one answer fits everybody. And then when you're looking at imposing masks as by the employer being mandatory, then yeah, the questions start to rise: who's going to pay for the masks? What happens if somebody doesn't wear the mask? And there's also other questions the employer has to address, is that if most of the masks that we're seeing obviously are disposable, is there going to be a workplace to dispose of the masks on the work site? How do the employees dispose of the masks? Also have to address the question is the mask actually going to reduce the risk of a spread of the virus? Obviously, if somebody's wearing the same mask their entire shift, whether it's a 4-hour shift or an 8-hour shift, if the whole idea is that the mask is going to potentially protect the wearer of the mask, and there's also the issue that the mask not only protects the wearer, but the other people that the wearer has contact with. But I think if the mask becomes contaminated, is there a risk that's just going to spread the contamination if somebody's wearing the mask for their entire shift? So there's a lot of questions that an employer is going to have to address in terms of disposing of the mask, avoiding cross-contamination. With a lot of personal protective equipment, I'm sure a lot of workplaces have the experience that if it's not done properly, if it's uncomfortable, if it doesn't actually meet its purpose and stuff like that, it's going to be very difficult to literally police everybody in the workplace, make sure it's fit properly, make sure they're wearing it properly. So if it's not doing its job, then what's the purpose of having a policy or potentially enforcing against individuals? In terms of the employer paying for it, it's going to be a question of looking at, again, what does the statute or the regulations say if it's imposed by the government? For places that are governed by a collective agreement, you're going to have to look at the collective agreement, see what the collective agreement says. A lot of workplaces are already probably highly developed. They'll have policy. Go back and look at your policy. Most likely, the policy is not going to address something specific as masks unless it was addressed previously by the workplace, but it may have a general policy dealing with personal protective equipment. If it's something that's mandatory by the employer, the policy may kick in and say that it requires the employer to pay for the masks, or there might be a general policy that says that the employer pays a certain amount annually for personal protective equipment, which would then capture the purchase of masks and providing of masks and stuff like that. But absent something specific by statute or by the collective agreement or by policy, there's not going to be a clear positive obligation by the employer to provide the mask to their employees. In this environment, it'll be within the discretion of the employer whether or not it's appropriate. You know, is it going to encourage compliance by providing the masks? And what I understand is that the cost of the masks are going down quite dramatically compared to what we've seen at the beginning of the COVID. So they're still pretty expensive, but a lot less expensive than we saw even a couple months ago. Thank you.
Okay, so a good starting point then for our employees would be to look at their current policies and procedures around personal protective equipment, use that as a starting conversation, and including your unions also, right, in the conversations, and have a conversation, I think is what you're leading to, because it's interesting. It just kind of expanded just as you were speaking, just from one question. And yeah. I do see Gabby has popped up, so that means we already have a question or a comment from our viewing audience. So hi, Gabby.
Hi, Angel. Thanks. Yeah, I'll be popping in and out as we get questions from the audience. So this is related to masks. This person is asking, for people who report they cannot wear masks due to a pre-existing medical condition, what are the options for the employer?
So that's a good question. And there's going to be a theme about that kind of question and other areas. I suspect we're going to see over the next hour, but also I think what we're going to see in workplaces as a general point is that a lot of my comments and a lot of the questions are dealing with just generalities. And when we're dealing with all of these individuals in the workplace, we have to be sensitive that they're going to have individual needs. And the question is a perfectly good example of an individual that has certain unique requirements that may prohibit them from wearing a mask, or it may have to be modified. And that's what we get into an area that we're touching upon in terms of human rights. So then is there a general obligation to wear a mask, whether or not it's imposed by statute or imposed by the employer? And the employer is going to have to be sensitive to the exceptions to the general rule. So it's great to have a rule that everybody has to wear a mask, but you also have to be sensitive that there's going to be exceptions to that general rule. And so just as much as employers have had to deal with in the past that certain rules apply to the majority of the workforce, then there's individuals that may have, for example, a disability or a sensitivity or something like that, where they have to actually accommodate that individual. So that kind of question is probably going to be dealt with through some kind of an accommodation process.
Yeah, and to your point, Brad, that's what I was reading about this week, because there's always going to be exceptions to the rule, and that is something that we always have to keep in the back of our minds around PPE, about mental health, about returning to the actual work site. So your point is well taken to consider that there's always going to be the one-off. So that leads us to the other thing that came in from our viewers this week. With the announcement that daycares can open during phase 3, and with school boards scrambling for their return to school in September, there has been a lot of questions about daycare. Right now, some employees are on emergency leave under the childcare purposes, and the questions were twofold. One, if I don't feel I can send my children to daycare, can my employer terminate my employment? Or two, if I am at a home office environment, working with my children at home and don't want to send them to daycare, or I'm waiting for school to open, can I keep that arrangement? Does an employer have an obligation to keep me in that situation? So that came out this week with the announcement of going back. So could you address that, Brad?
Certainly, and obviously the daycare is very much top of mind for a lot of people, both employees and employers. And this is something where we're going to have to look into the future and honestly see how this is going to evolve between now and the beginning of September. Because the need for daycare is going to be influenced by so many different factors that are beyond all of our control. But getting back to the question specifically, so there's probably three very broad areas that have to be looked at here. So one is going to be just, I would call, the general leave that an employer may provide to its employees. It's always within the discretion of an employer most of the time to just very simply give somebody a general leave if that's appropriate under the circumstances. And that requires a reference back to what the policy may be or the past practice of the employer. So that's something that's probably been in place all along. We've also got the Human Rights Code, and there's an issue of family status under the Human Rights Code. And so the discrimination on the basis of family status has been in the code for a long time. And the case law on that has been evolving and developing literally in recent times over the last few years. And so if somebody can't report for work as expected because of daycare issues, that's generally accepted that's an issue that's protected under family status under the Human Rights Code. So if that arises, then the workplace, the employer and the employee, they have to go through the process of doing an appropriate analysis under the Human Rights Code, which includes an employer having to accommodate the employee up to the point of undue hardship. And that takes into account an awful lot of points, including, for example, that if the employee wants to stay home to look after the children, well, that sounds more like a preference than rather being a true daycare issue. Or if the employee says, well, my daycare isn't open, I don't want to take my children to some other new different daycare center and stuff like that. That may fall outside of the scope as what is an appropriate obligation to accommodate. So there's going to have to be an awful lot of fact gathering in order to address that question. Something that's quite unique because of COVID is how the Employment Standards Act has been amended. And so the Employment Standards Act has been amended to create what's called the Infectious Emergency Disease Leave. And there's a whole bunch of different reasons why somebody can access that leave. But the one relevant to this question has to do with daycare. So if somebody can't work, and they otherwise meet the obligations, or excuse me, meet the criteria to access the leave under the Employment Standards Act. So if they can't work because of daycare and it meets the criteria of the Infectious Emergency Disease Leave, then they actually have the protection of a leave under the Employment Standards Act. And just very generally, that means they have the same protections as any other leave that exists under the Employment Standards Act. And most would probably deal most frequently with issues of, say, maternity leave or parental leave and stuff like that. So if somebody has access to the emergency disease leave under the Employment Standards Act, then that's going to not only give them the right to go on leave, but it's going to protect their job, but also protect their position. So if they're properly on that leave, then they have that element of job protection. One of the unique aspects of the emergency disease leave, though, is that it's going to stop by regulation of the government. So in most situations, again, draw a parallel with parental leave as an example, the individual employee has a lot more control over when they stop and start that kind of leave. Nobody had control over the disease leave because when they passed the regulation, they deemed people who are on leave to be on the emergency disease leave. So it started by regulation, and it's also going to stop by regulation because it's going to stop 6 weeks after the emergency order expires, which currently puts it into September. But again, that may be subject to change by the government. So most people, I suspect, in a scenario of dealing with not being able to work because of daycare, they're probably going to fall under that umbrella of the emergency disease leave under the Employment Standards Act.
And Brad, can you just clarify one thing when you talk about leave protected under ESA? These are unpaid leaves?
As a general rule, that's right, yeah.
Okay, thank you. So now what we're going to do, Brad and viewers, is we're going to start addressing the three themes that came out of your questions that you provided when you registered. So the first theme is about general considerations. And one of the questions that was asked, Brad, numerous times was, how does an employer make sure that their workplace is safe and is ready for those returning to work as we open up?
So that's multifaceted. So if we look at what the legal obligations are as an employer, we can take reference to the Health and Safety Act, for example, that you have to acquaint the worker with a hazard. We have the very broad duty, I think most of us are aware, in terms of providing information, instruction, and training to the workers. And then the very broad duty, of take every precaution reasonable in the circumstances. And quite often it's that duty under 25(2)(h) of the Health and Safety Act that gets applied in situations that are, I'll call it, new. And obviously this is the newest of new situations. And it also imposes on the employer the duty not only to follow what we might call the black letter law, what's exactly stated in the Health and Safety Act or what's stated in the regulation, but it also requires the employer to look beyond that and say, okay, fine, what's my industry? What's my sector? What's the standards that are being applied in my sector? What's the standards that are being applied in other workplaces of a similar size or geographical location? Requires, essentially a risk assessment of what's going to happen when I bring my people back to work. So when we look at, going from phase 1 to phase 2 and phase 3, and then presumably beyond phase 3, that's going to require a lot of employers to assess and reassess as the circumstances change. So if you think of just a very, very simple example in terms of a workplace that is, because of whatever phase they're in, they don't have contact with the public, and then suddenly they're going to a reopening situation where now they're going to have contact with the public. So that's a whole different set of risks that that the employer is going to have to address. They'll have to look at potentially municipal guidelines, provincial guidelines, your local health unit guidelines, and even if you're not federally regulated, look at what the federal guidelines are, because again, a lot of this is truly new. And when we look at the every precaution reasonable standard, it's basically saying, as an employer, you can't be negligent. So that requires the employer to inform itself. And again, because there's really no precedent of what we had before March, that really means most employers will actually have to take a positive step to inform themselves and to educate themselves. And then ultimately, that's going to have to trickle down to the supervisors, because we know the supervisors have duties within the workplace, and we know the workers have duties within the workplace. So the employer is going to have to inform and educate itself, and then distribute that information in one form or another, whether or not it's policy, informal training, actual training. Again, we talked about PPE, providing training on when to use the equipment, how to use the equipment, so forth and so on. Thank you.
So Brad, would you then suggest that employers talk to their employees, talk to their joint health and safety committees, talk to their unions when they're doing their risk assessments to ensure that they are encompassing all the risks that can be involved? And I know in the last probably 15 or so days, I've been seeing a shift to include the psychosocial part of the risk assessment when they're going back to work. Would that be accurate?
So we all know that quite often the workers are actually working on the front line quite often have the closest contact with what the risks may be. And they quite often have valuable input in terms of, identifying what the risk is, but also assessing the extent of the risk. How significant is that risk, and what's the degree of harm. So there's no doubt there's that consultation should be an important part of that risk assessment. But I think there's another aspect of it, and this gets into your question about the psychosocial aspect of it, is that I think, it's largely anecdotal of what I've seen so far, but I've seen it in the context of health and safety analysis, but also, what's good for the employers, what's good for the employees, and that is having better communication about what's going on and what the risks are, because what we're seeing is an awful lot of stress and anxiety, and it's, in many ways, it's completely valid because we're living in a huge period of uncertainty. So if the employer has some information, and sometimes it's communicating not having the information, that'll be helpful itself, so that at least the employees will know that the employer is being proactive. And I think a lot of people that, again, this is largely anecdotal evidence, is that I think a lot of workplace and a lot of employers, if they're getting positive results in terms of trying to maintain employee morale, for example, it's probably going to be centered around that aspect of communicating with the employees, so that, even if there's still a period of uncertainty, then just simply communicating, you're not the only person who has uncertainty. You're not alone in this process. If you use the expression, misery loves company. Well, we're in a lot of misery because of the anxiety and the stress that we're going through. We just like to know we're not doing it all by ourselves. But again, if the employer is out there gathering information, processing the information, it's helpful to pass that on to the employees when in fact it's available.
Yeah, it is. And to your point, just knowing we're all on the same journey. We've taken different paths. maybe using different vessels, but we're all on the same journey. And one of the things that we did as we're preparing to return to work is we called each and every employee and we asked them, what are your fears going back to work, and what are your anticipated challenges? And sometimes it was just the opportunity being given to talk and know that they weren't feeling the same or different than other people was a huge opportunity for people to, what you talked about is communication. Sometimes we forget about that. So one of the other questions that came under the general theme, Brad, interestingly enough, is about this shift from working in an office to the exodus to the home office. So a couple of our viewers had questions about, how does WSIB work? If say I get hurt, this is my home office here. If I get hurt during my Workplace Safety North hours, how does that work for WSIB?
Well, fundamentally, it's going to work as it has in the past. And there's some kind of easy parallels that we've seen in the past. So this is not the first time that people are working for the employer outside the actual physical confines of the workplace. So it could be that, they travel quite a bit. It could be that sometimes the car is the workplace because that's what they're doing. It could be that they're going to client premises, and the client premise, whether it's a house or an office, is the workplace on a temporary basis. So the workplace very generally can shift. So fundamentally, if somebody's working from home, if they have a home office, that's now their workplace. And if they get hurt working from home, fundamentally, the WSIB rules that we've seen historically still apply. There's a duty that the employer has to report the accident. Obviously, there's a duty of the worker to report the accident. You know, the WSIB will do its own assessment to determine whether or not there's entitlement. And then if there's entitlement, then you have the healthcare benefits, a loss of earning benefits that arise in any situation when there's a workplace accident. So the WSIB has created some policy that is unique for COVID to assess whether or not somebody actually has contracted COVID. But there's also just the same issues you're always going to arise. You know, somebody can have an ergonomic injury, or they can have a slip and fall, et cetera, et cetera. Fortunately, considering that whether we have
technical difficulty, so just bear with us. We're going to hope to get Brad back. Gabby, perhaps you could dial into Brad. You see.
Angel, I think it might be on your end because you're frozen, but Brad's still here. So, Angel, are you still there? Okay, well, we'll just continue along. Maybe we'll get Angel back soon. I had some questions from the audience here. So the first one is, can you expand on the right to refuse, where a worker believes the workplace may cause them to contract COVID-19?
Yeah, that's a good question also. And so, again, when we look at the right to refuse, the rules are set out in the Occupational Health and Safety Act. So if you're provincially regulated, and I assume that we probably got some federally regulated employers on the conference. If you're provincially regulated, you're obviously looking at the Occupational Health and Safety Act. If you're federally regulated, you're going to be looking at the Canada Labour Code. But generally speaking, those rules are very similar under both pieces of legislation. And so if we ever had to go through a right to refuse, most people have experienced that the first stage is that the person actually engages the right to refuse. So that typically means they're at their workstation or their work location that actually presents that risk to them. And so they have to identify what is unsafe in that given set of circumstances, report it to the employer, and essentially the employer is going to do an investigation or inquiry at that point in time to assess what the risk is and whether or not it can be addressed. So at that first stage, the expectation is that between the worker and the supervisor and the employer, they can properly assess whatever that risk may be in a given set of circumstances. And if they can address the risk, then the worker goes back to work and the refusal has been properly resolved at that stage. If in fact the workplace parties can't address what the risk may be or address the refusal, or the worker continues to refuse to return to work, then they engage the second stage, and that involves getting the Ministry of Labour involved. So at that point in time, what they do is the worker should be reporting it to, or one of the workplace parties report it to the Ministry of Labour. The Ministry of Labour would then do an inspection. Sometimes it's in person, sometimes it's going to be over the telephone. It'll be interesting to see whether or not how it's going to be done during the COVID that we're experiencing right now. But then the Ministry of Labour goes through, does their investigation, and if necessary, they can make a finding and make an order against the employer to provide equipment, modify the procedure, whatever is necessary in order to address the hazard that the Ministry of Labour had identified. And so that at that point in time, the goal is that the employer would address the hazard that's been identified pursuant to the order of the Ministry of Labour, and then presumably the worker can go back to work at that point in time.
Okay, good. Another question here, a little bit different, but still talking about like leave from work. So when an employee opts to leave work because of an underlying medical condition due to COVID, how long do you have to keep the position available to the employee, especially when the position must be filled to fulfill contract obligations?
So that's going to depend on several different factors. So if somebody leaves the workplace because of, I think you mentioned, underlying condition, if they leave the workplace, the first way that might be analyzed is very simply as a disability under the Human Rights Code. And if you analyze it on that basis, then you're really applying the same rules that have existed for years across all jurisdictions. So does the person have a disability that's as identified under the Human Rights Code? What's the limitations or the restrictions arising from that disability? What, can the employer accommodate that individual based upon those restrictions and limitations up to the point of undue hardship? And if that means that the employer can't accommodate and bring that person back to work because of limitations and restrictions, that doesn't mean that the employer suddenly has some kind of automatic right to terminate. Quite often in the disability analysis is employees have a disability, but quite often it's temporary. They're going through some kind of treatment. And so there's no suggestion, and it would be a clear breach of the Human Rights Code or at the federal level, the Canadian Human Rights Act, be a breach of the legislation if somebody simply says, oh, you have a disability, I can't bring you back to work, therefore I'm going to terminate you. That would be a breach of the employer's obligations. When you're in that time period where it's a disability that is temporary or the person is undergoing treatment, essentially the person is going to be on leave and they have the protection of the Human Rights Code and a right to come back to work, either to come back to the original position or come back to comparable employment, depending on what the circumstances are. And unfortunately, we can't put a time limit on that. That is very unique to the individual because, as we all know, a human rights assessment is very much individualistic to that particular employee and his or her needs and the circumstances of the workplace. So we can't put a time limit on and say, well, if you're not back to work after 90 days, I'm going to terminate you. Or if you're not back to work after 60 days, I'm going to terminate. Unfortunately, that can't be done. It has to be assessed at that point in time in the future. So if somebody today is saying, I can't work because of an underlying condition and COVID, it may be that if they can't be accommodated, it means that they're very simply going home. It would be an unpaid leave unless they have access to the SERB, for example, or short-term or long-term disability, those kinds of situations. But the employer would be able to fill the position temporarily, but the employer had to be in a position to have that person return back to work, either in the position they left or to comparable employment, depending on what the circumstances are. Thank you.
Great. So within this second theme, we're talking about general health and safety of workers, absenteeism, work refusals. Something that came up a lot in questions was around absenteeism. So an employer notices their staff aren't working their hours from home. What rights does an employer have, and how to go about addressing that?
Well, the simple answer to that is to some extent ignoring the complications that we have surrounding work from home. The simple answer to that is that I look at it that there's a fundamental agreement between the parties. The employer employs the employee provides his or her services, and at the end of the day, the employee gets paid for providing her services. So that's just the fundamental bargain between the parties. So if it's just to use as an example, the employee is supposed to work 9 to 5. Fundamentally, that doesn't make any difference whether or not it's at the office, it's in their car, it's at the client workplace, or it's at their home. It's the same basic bargain as they've got to provide whatever they've agreed to provide. And if the employee is not providing his or her services as they agreed to, then you get into issues of potentially whether or not it's a disciplinary issue and all the way up to the point of being a termination. It is admittedly much more complicated in a work from home scenario because there's probably going to be very little, if not no supervision whatsoever of that employee. But if you look at a lot of the areas, and this gets outside of health and safety issues, it's more in terms of human resource management or business management issues, but there's a lot of recommendations in terms of how to make sure that the employees are engaged. Because, I think we can look at it optimistically. The vast majority of employees want to work and they want to provide the services that they've agreed to provide. But I think we also have to acknowledge that when working from home, there's a lot more distractions, whether or not it's they've got some childcare responsibilities, looking after their pets, or they've got other people in the house. There's just that many more distractions. There's things that the employer can do to make sure that the employees remain engaged. And that would include, quite often having the equivalent of a virtual tailgate meeting every morning, outlining what the workday is going to look like, or checking in on periodically, whether or not it's random checking in on them, by telephone or these days by Zoom, checking in on specific times or checking in on randomly, checking their work progress, so you can still supervise, so to speak, a worker from a remote location to make sure that they're performing properly. But fundamentally, it's that what's the agreement between the parties? And I think it's going to be important that employers have a proper work from home policy, because if the standard policies don't apply, or it's a poor fit when somebody's working from home, then that's an indication that you're going to have a proper work from home policy. And the simplest example of that is that, typically when somebody's at home, that's their off time, and generally an employer doesn't have a right to call an employee, or they don't like to call an employee because you're disturbing them at home and stuff like that. Well, when they're working from home, you're going to have to call them at home, whether, and if they don't have a work phone, like an assigned cell phone, for example, then you're going to have to call them on their personal number or their personal cell phone, or, so there's a lot of those kinds of questions that will have to be addressed by way of policy or changing their practice.
That's a great point. So on another note, related to testing positive for COVID. So if a worker tests positive for COVID, do they have to tell the employer?
So part of that is going to be addressed by what is the requirements out there, whether or not it's under the Health and Safety Act, for example, whether or not it's under workers' compensation legislation, whether or not it's going to be pursuant to guidelines of the local health unit. So a lot of that may be addressed by what I would call external obligations. It's not necessarily something that the employer is imposing. So again, to use the simple example, and we already touched upon it briefly, the idea that somebody wants to access workers' compensation because they believe that they contracted COVID while they were at the workplace. Well, that's just like any other workplace injury or workplace illness. There has to be a sharing of information between the worker and the employer, so that the employer can do the proper notice and the employee can do the proper notice. So that's an example where, whether or not the employer has to, the employee has to share that information is really governed by the rules that we had before COVID came along. But there may be unique rules to COVID, and again, that might be something that's created under the health and safety legislation or by guidelines by various government branches. The employer might also have a policy, and again, this is something that the employer, if they don't have it in place, want to consider whether or not they address, and that is, what kind of information has to be shared by its employees. And so, at the end of the day, an employer can't force an employee to share something confidential as a diagnosis. But if the employer has the belief that somebody has tested positive, or they've had contact with somebody that had the COVID, and if the individual is not willing to share that information, then the parallel is like in a lot of other situations, is that the employee doesn't have access to the workplace. And so if the employer has that suspicion that somebody's contracted or had contact with somebody who has a positive test for COVID, the employer has an obligation to protect the rest of its workers. So if they have the belief that somebody's been tested positive, and if they can't eliminate that concern, then they have to make sure the person is kept out of the workplace. And therefore, the employee, if the employee refuses to share information in terms of, yes, I was positive, but now I have a negative test, if they're not going to share the information, the employer may very simply have to say, you can't come back to work until I get an appropriate negative test.
Absolutely. Related to that question, if I test positive for COVID-19 and have to quarantine, does my employer have to pay me during that time?
So the first point would be simply say, no, that's not correct, or that no, they don't have to pay the employee. But that's subject to obviously some of the things we already talked about in terms of workers' compensation. So if somebody tested positive and they can prove that they contracted at the workplace, then they're going to have access to workers' compensation benefits. So that's not money coming from the employer, but a lot of workplaces also have things like sick time or weekly indemnity or short-term disability benefits or long-term disability benefits or other benefits that arise under their policy or their past practice. So some of those benefits are paid by a third party, by an insurer, so it's not coming from the employer. But sometimes things like sick leave and short-term or weekly indemnity are actually self-funded by the employer. So there may be situations where the employer is going to continue some or all of the wages, but it's not the same thing as earned wages. It's something that's going to rise under the disability or the sick leave policy of that particular workplace. So the general rule would be, no, the employer doesn't have to pay just because they're being quarantined, but you have to look at whether or not they have access to some kind of sick leave or disability benefits through the workplace, and can get some or all of their wages continued under sick leave or disability benefits. Thank you.
Okay. The question here that just came in from the audience. So they say, I work for a First Nation who wants to enforce that employees who travel outside of the region must self-isolate for up to 14 days or until a negative test is received before they can return to work. Legally, is the employer allowed to do this?
So I'll interpret that question as just being somewhat generic in a context that if somebody's traveling, and again, whether or not it's outside of the region, outside of the province, or even internationally, can the employer impose a 14-day quarantine or something similar to that? And again, what's important about that is it's just like any other policy, is that the employer has to put its mind, its collective minds to, what is the rationale of that policy? Is it reasonable to have a policy like that? And did they create that policy in form of the employees? So there's several steps that an employer has to go through to create a policy that would make it enforceable. Now, if it's a unionized workplace, then there is a fairly specific process that they have to go through to create an enforceable policy. Otherwise, it can be challenged under the collective agreement. If it's a non-unionized workplace, the employer has a little bit more leeway in terms of essentially unilaterally imposing the policy on the employees. But the risk is that if the employer doesn't properly have a policy that allows it to, in fact, exclude the person from the workplace by simply saying, you've got to stay home under self-quarantine for a certain period of time, the risk is that the employer is going to potentially engage in what's called a constructive dismissal. So they have to have a policy where they can say, we have the right, when our employee has traveled beyond a certain geographical limitation, we have a right to say that you can't come back to work for a certain period of time. So if they've built that into the terms of employment, and in these situations most likely going to be pursuant to a policy, if they've built that into the terms of employment, then yes, the employer can say that you would have to stay home and self-quarantine because of where you were traveling.
Good. This question is related to a vaccine. So once a vaccine actually comes along, it's out there, it's able to be accessed by the public. Can employers force their employees to get it, and can they be let go if they don't?
So that's going. Part of the answer to that question is going to involve all of us doing a little bit of crystal ball gazing in a context. What are we going to see for legislation, federally or provincially or from the health unit? There are some rules that we've seen historically that apply to vaccines, in particular, quite often in the healthcare sector, or in the educational sector. So there's some rules out there that we might be able to apply in other sectors that have never had to deal with a vaccine in the past. But the caveat on that, and again, I think it's going to be a pretty big caveat, is that once the vaccine comes along, I think the optimistic rate now, guess, is that we might see a vaccine in a new year. That's roughly a half a year from now. Well, if we go back and see what's happened in the last 4 months, we can see how quickly things have changed. So if a vaccine comes along and we don't see it until January, everything's going to be changing. There's a pretty good argument that a lot of aspects of our society is going to change because of the coronavirus between now and January, but certainly the law is going to change. So that is a question that, and I'm not begging off the question, I'm not being evasive here, but that's really a question that we're going to all have to ask ourselves as individual employees or as employers, or just generally citizens, come January, whenever that vaccine comes along. Because if the legislation imposes it upon everybody, that decision is taken out of the hands of the employer. And again, the employer may have to say, again, depending on what sector they're in, because again, I suspect a requirement for a vaccine will in fact be done on a sector by sector basis. But if the legislation comes along and says that the vaccine has to be used by certain individuals in a certain sector, the employer is probably going to have an obligation not to continue to employ those individuals until they prove that they've been properly vaccinated. At the same time, if it's not specifically required by legislation, again, some employers might be able to do that by way of policy. And again, it's just like any other job requirement, you know, and it might draw the parallel with personal protective equipment is that if in fact the employer requires by policy as terms of employment that they have to be vaccinated and then they don't get the vaccination, then that again might mean that the employer does not have to allow them to enter into the workplace. It doesn't necessarily mean that it's going to lead to a termination, but it means that they're not going to be employed, which means they're not going to get their wages. But then at the same time, whether or not it's mandatory by legislation or the employer does it on its own, you're going to have to deal with all of the issues that we've already touched upon in terms of, you know, are there reasons why the employee doesn't get the vaccination? You know, is there a ground that's protected under the Human Rights Code? And so if there's a ground under the Human Rights Code that justifies a refusal to get the vaccination, then the employer is now looking at having to do accommodation of that employee's needs up to the point of undue hardship. So that's probably the best I can do under the time period we're in right now and the time that we have this afternoon. Thank you.
Absolutely, and that's a tricky question. I guess really only time will tell as we get more information about a potential vaccine. So this question is related to general health and safety in their home workspace. So if my home is now my workplace, am I to complete assessments and documentation? So will my employer have to do an assessment of my workplace?
Well, fundamentally, the short answer is yes. Whether or not it's an assessment for COVID-related reasons or whether or not it's an assessment for other reasons, like most people that are working from home are going to be some kind of office workers. So that engages issues of ergonomics as an example. So for a short term, going home and working for a few hours or even a few days or a couple of weeks, some people would just simply say, well, I'm just going to work at my dining room table. For a short term kind of emergency use, that's probably fine. But if somebody's going to be working from home for a long period of time, they really should have their ergonomics that they have at their place, whether or not that's a proper office chair, a keyboard height, the monitor height and placement of their mouse, and if they've got a printer and a scanner. All of those issues would have to be arguably addressed at the home environment as much as they have to be addressed in the office environment, which sometimes might mean that a person actually can't work at home. If they're not going to allow that kind of ergonomic assessment, for example, then that means that it might mean that they can't work from home. Or if the needs of the employee can't be met working from home, again, that's part of the decision-making process that both the employee and employer have to engage in terms of whether or not they can properly work from home. But in the environment of dealing with COVID, that may also have to be assessed too in terms of, are they similarly at risk or maybe even a greater risk at their home compared to if they're working at the office. So if somebody's not working in the office because of the risk of COVID, just because they're working from home doesn't mean that risk has been eliminated. So again, overall, yeah, there may potentially have to be an assessment of the workplace at home for various health and safety reasons.
Okay. And are employers required to provide certain ergonomical desk setups? Is there any requirements around special chairs or desk trays or anything that you would need to be comfortable at home?
So again, that's going to depend upon the reasons why somebody's working at home and the duration. And so just to use as a simple example is that if, at the beginning of COVID, a lot of employers were scrambling because they were faced with, unless they could get some employees to work from home, they weren't going to be working at all. And so in a situation like that, this is the employer saying, well, going to the employee, can you work at home? And it's quite often it's going to be on a temporary basis. So the cost of outfitting a home office in a situation like that might actually be cost prohibitive. So that's an issue that the employer has to address in their decision to ask the employee to work from home. And that's also going to be a decision that the employee has to make in the context where they're being asked to work from home. But if they need certain needs in terms of equipment, for example, are they going to be able to work from home if the employer doesn't provide that equipment? On the other hand, if the employee is the one who's saying, well, rather than working in the office, I'm making a request to work from home. And so a lot of what we're seeing is that this may be a new, for some workplaces, this may be a new standard, because a lot of employers and a lot of employees are learning that when somebody works from home, maybe they're similar productive at home as they are working from their office, their workplace and stuff like that. So employees might have a desire to work from home. If nothing else, it's less of an issue for me here in Thunder Bay, but for some folks in Southern Ontario, working from home is gonna add, maybe a couple hours to their day because they don't have a commute anymore. So there could be a real incentive to work from home. So if it's the employee who's asking to work from home, then it might also be the employee in that situation who actually has to outfit their home office. They have to create a home office for themselves. And then you also get into issues, not only in terms of equipment and ergonomics, but you also get into issues of privacy and confidentiality and securing information, securing documents and stuff like that. So some of those questions you can get a shortcut answer to because it's on a temporary basis. But if it's going to be more long-term or permanent, then some of these questions actually have to be properly answered, because if somebody has a risk due to poor ergonomics, and if that can't be fixed, the answer may be they can't work from home.
Mm-hmm. Thanks for clarifying that point. I'm just going to take one more question from the audience before we move into our last theme, which will be employee responsibilities. And this question may fit into that. So the question is, if I travel on my personal time, can I be terminated or forced to take leave without pay because I'm required to quarantine when I come back to the country/province? I think we answered this a little bit earlier, but just to address this question.
Certainly, yeah. So if somebody has to quarantine because of something that they did on their personal time, and traveling is a good example of that, if the employee can't work and provide their services, the short answer is they're not going to get paid, unless there's some other kind of term of employment or policy that kicks in. So if there is a term of employment or a policy that says that if somebody has to go on a leave for certain reasons, and again, sick leave is a typical example of that. So unless they go on leave for certain reasons, it's going to be an unpaid leave. Now, if somebody is required to quarantine, or because they were exposed to somebody who had a positive test for COVID, it's going to be a question of looking at whether or not that would fit within the terms of the policy, or the sick leave policy, or the disability policy, or the disability plan. Obviously, if it's by a third-party insurer, the employee would very simply apply for the disability benefits, and it'll be up to the third-party insurer to determine whether or not they fit within the definitions of a disability, and they have access to the benefits.
Okay, great. So now into our last theme around responsibilities of employers and employees. As an employer, how far do you have to go when it comes to COVID and protecting your workers?
So I think the ultimate test, I guess, is that most of us probably would be aware of is that taking every precaution reasonable in the circumstances. That is, the employer has to make sure that they're not negligent. And as we've probably talked about in other forums and other presentations, and what the case law tells us, that's not a standard of perfection. It's a standard of what's reasonable in the circumstances. Now, when we're dealing with such a unique situation as we're dealing right now with COVID, there's no clear rules of what an employer should do in any given set of circumstances. It's not as simple as saying, I've got a piece of industrial equipment, it's got a pinch point, therefore I got to put a guard on it. That's as clear in black and white as we see historically. We can't sit there now and say, well, I operate a movie theater, or I operate a restaurant, or I operate a law firm. Here's exactly what you have to do. It's more a question of the employer seeking out the information of what's available out there. And because it's almost constantly changing, unfortunately, it's always going to impose an obligation on the employer to not only get acquainted, but to stay acquainted with it, what the circumstances are out there. So if the employer, decides what the standard of behavior is on June 30th, and the circumstances have changed by July 31st, the employer has to be in a position to determine what the new standards are, what the new standard of care is. Because when we look at every precaution reasonable in the circumstances. And like I said, because it's essentially, requires the employer to not be negligent. The fundamental question is, what is the appropriate standard of care in those circumstances? And the employer simply has to inform itself and figure what that standard of care would be.
Absolutely. And then on the other side of the coin, what are my legal obligations as an employee?
So I think the starting point, and we can look at the Health and Safety Act, we can look at workplace safety, we can look at human rights, but just for the time being, focusing on the Occupational Health and Safety Act, we know that the worker, in the same way that a supervisor and an employer has, but the worker has an obligation to report a hazard. So they've got that positive obligation to report a hazard. That's arguably puts a positive obligation on the worker to say that they've been exposed to somebody with the coronavirus, or they believe that they have the coronavirus. That's a hazard. So there's a very good argument the employer has an obligation to report that to his or her supervisor. They have an obligation to report defects in equipment and non-use of personal protective equipment, those kinds of things. As we've touched upon probably at the very beginning of this session, they obviously have the right to refuse work under the Health and Safety Act. So they have an awful lot of duties that they have to follow, but they also have an awful lot of rights under the Health and Safety Act, the Workplace Safety Insurance Act, Human Rights Code, and most likely under the policy of their specific employer.
It's a great summary. So we're almost out of time. So I do want to give you the floor. Just if there's anything you want to share before we wrap up, feel free to go ahead now.
Sure, absolutely. I think just when I put on my hat as a lawyer, I think the idea that we're in interesting times is an overused expression. Is still incredibly relevant, but in the context of being a lawyer and practicing this area, it is certainly a really interesting time and a challenging time, because the idea is that as lawyers we practice the law. We take what we've seen in the past, legal principles, and we apply it to current circumstances. But right now, what we're seeing right now is that the law is changing sometimes on a daily basis. The facts are changing certainly on a daily basis. And so it's an interesting time for us as lawyers, and I appreciate this probably makes it more difficult for employees and workers out there, because all of the facts and all of the law is changing almost as we speak about it. I guess maybe a parting comment that I'll give to everybody is that you always have to be context sensitive of what your question is and what the answer may be, because just in this hour-long session, I've touched upon principles of law that come from what we call the common law, that's judge-made law. We've talked about the Occupational Health and Safety Act. We've talked about the Employment Standards Act. We've talked about the Human Rights Code. We've talked about the Workplace Safety Insurance Act. And the question that you have really has to be context sensitive of what area of the law are you talking about, because you're not necessarily always going to get the same answer every single time. So I just ask you or recommend that be aware of what the context is and gather the information from all of the sources you can before you make a decision. Thank you very much.
Great, and thank you so much, Brad, for joining us today. We so appreciate you sharing your expertise with us. And I want to thank everyone that joined us here today on this webinar. And I want to announce that we are going to be hosting our next webinar on August 26th. The topic is Returning to the New Normal, Challenges, Successes, and Key Learnings. So stay tuned for more information on that. And do note that this webinar recording, along with resources, will be sent to you within 1 business day. So thanks again, and we will talk to you again soon.